Okay, Assalamualaikum and salutation. So today we will present about our project paper, which is about development of force majeure clause in light of COVID-19. So my name is Fawwaz Sulhi bin Ahmad Sinwan, and my partner is Muhammad DANIAL IMAN bin Ahmad TERRIRUDIN. So with regard for the background of study, at the end of 2019, the coronavirus disease 19, which is COVID-19, had shaken the world when it was discovered. When the coronavirus hit Malaysia, the Malaysian government announced the Movement Control Order, which is MCO, implementation throughout the Malaysia, which take effects from 18 March 2020 till further notice. In the in the view of the economic perspective, the outbreak has dampened the global economic activities and retail companies of all scales. Hence, some contractual being obstructed because of the outbreak, while others may also be struggling to meet their obligation under the contracts, and several of them have been wondering whether there is any sort of contractual protection that may be seeking relief at this time of uncertainty.
Now we moved on towards the research methodology in our project paper. We have identified two methods that we use for our project paper, which is the phenomenological method and the doctrinal method. For the phenomenological method, we use to find related articles, using law and also using law-based servers and also journals. Law-based servers consist of CLJ and LexisNexis. And for doctrinal method, we use a systematic exposition of rules governing a particular legal category, and we analyze them with the relationship between regulations and where it explains our future developments of our research in our project paper. Now we move on to our problem statement, where we focus on four statements in our project paper. One would be whether the pandemic of the COVID-19 can be regarded as a force majeure event. Second, whether the term of the disease, epidemic, or pandemic can be invoked the force majeure clause in the contract. Third, the comparison between the applicability and of the force majeure and doctrine of frustration in light of pandemic of COVID-19. And fourth, how the drafting of the force majeure clause can be triggered due to the effect of COVID-19. Now we move on towards the research objective. We identified three research objectives to our project paper, which is the first is whether we want to determine the COVID-19 outbreak can be regarded as one of the events under force majeure. Second is the applicability of force majeure and doctrine of frustration during the COVID-19 outbreak. And third, to understand the drafting of force majeure clauses in light of the COVID-19. On towards our discussion and analysis. So on our first discussion of analysis, we will be talking about the formation of contracts, where there are four essentials that founded the concept of contract, which is offer, which is pursuant to Section 2A of the Contract Act 1950. Second would be intention to create legal relations. Third would be acceptance, which is regarded as Section 2B of the Contract Act 1950, and consideration, which is under Section 26 of the Contract Act 1950.
Okay, so once a contract has been formed, if one of the parties cannot perform its obligation, especially in this time of pandemic, a party can use the doctrine of frustration or force majeure clause within a contract. So what is actually a force majeure? So a force majeure is a clause which gives an exception to the parties to not perform a contract. So with regard to the force majeure event, it can be defined as the occurrence of an event which prevent the impeached party to perform their contractual obligation under the contract. Okay, so one of the example of the force majeure event can be divided into two, which is inclusive and exclusive. So inclusive is provided as a more excellent range of event in which it was outside the reasonable control, and the affected party could not prevent or avoid it. Okay, so with regard to the inclusive, it can be regarded as the act of God, which such as cyclone, earthquake, drought, meteor, and etc. So for the exclusive definition, it was an event in which it is not open to the parties to interpret. So these circumstances are beyond the control and without the fault of negligence of the party after the party has taken the reasonable diligence but still unable to prevent it. So in this case, it can be a riot, war, ionizing radiation, insurrection of military, and etc. Okay, next. So for the element and effects of the force majeure. So under the force majeure, there are three elements that need to be proved. First one, the impediment is beyond the reasonable control. Second, the event cannot reasonably be foreseen at the time of the conclusion of the contract. And third, the effect of the impediment could not be reasonably be avoided or overcome by the affected party. So once the element have been fulfilled for the force majeure, it will trigger the effect of the force majeure, which is it. First one, it will give an excusable delay, which the completion of the contract could be extended, and the last one is to avoid the other party from claiming the non-performance of the contract. Okay, so we move on to the alternative defense, which is the doctrine of frustration. So this doctrine serves as an alternative way, aside from the force majeure clause, and pursuant to the section 57 subsection 2 of the Contract Act. So under the doctrine of frustration, there are three elements that need to be fulfilled before it can be triggered. First, the frustrating occurrence must not be part of the clause in the contract agreement between the parties. And the second one, frustrating circumstances was not from self-induced and not foreseeable. The third one, and the last one, which is frustrating occasion, has unexpectedly altered the occurrence to make the performance of the contract massively different from what was initially undertaken, and the court will find it unfair to enforce the original promise.
Okay, thank you, Fawwaz. Now we move on towards the drafting of a force majeure clause in light of COVID-19. So due to the pandemic, there are a few amendments that can be made towards existing and also new contracts in light of this pandemic. Therefore, there are 7 steps. We move on to the first step, where parties should analyze, parties who are entering into a contract should analyze whether a party may be excused from performance of an obligation with a review of the contract's force majeure clause. After that, on the second step, parties should consider including a specific reference to pandemic or disease. Besides that, parties should also consider including a specific reference to measures of any government authority, such as standard operating procedures or SOP, in response towards the pandemic. And lastly, parties should also consider adding language providing that the performing party is relieved from performance, whether there's any underlying unapplicable event. Now, for the third step is which parties should consider the standard of relief of the contract, where the parties should consider the appropriate standard for relief that must be established to excuse performance under the force majeure clause. On the fourth step, where parties should have a full coverage of the covered force majeure events and foreseeability in the contract, where these parties have to provide notice to its counterparties, including a commitment to identify the expected duration and effects of the force majeure event. Secondly, they should also consider qualifying the clause in future contracts to make explicit that only good faith estimates need to be provided, and these estimates are only just for informational purpose only, which is non-binding. For the fifth step is that parties have to consider the mitigation or the remedies efforts in a contract. Therefore, these parties have to consider carefully what level of efforts it would be prepared to undertake when negotiating its recovery obligation commitments. Second last step would be the consequences of force majeure, where these parties have to consider whether one or both parties should have the right to terminate the agreement in the event of a prolonged force majeure event, whether it's caused by COVID-19 or any governmental response measures or any other factors. Now, the last step is that parties should have a COVID-19 specific clause, where these parties should consider restructuring and negotiating a new contract, whether to include a separate or a detailed standalone title to address the consequences of performance in light of this COVID-19 or any governmental measures that is from the COVID-19 pandemic or any other force majeure events. So,
So we have reached the conclusion, which is the COVID-19 has left the legal industry with great challenges, especially information, drafting, and interpretation of the contract. Since there is no judicial precedent on this matter, most judges and legal scholars depend on their interpretation of one another to uphold the justice. Second one, the COVID-19 outbreak can be considered as a force majeure event depending on the term used within the clause of the contract. Apart from that, there are also some contracts that had to be terminated to prevent from the liability of the non-performance of the contract. Thus, the doctrine of frustration had to be applied in the lacking of force majeure clause.
to wrap it up, COVID-19 has left enormous difficulties for many parties under these agreements. Hence, the parties in negotiating new or existing contracts will need to build a force majeure clause and amend also certain clause that will help deal with the effects of the current pandemic based on the governmental measures. That is all from our presentation. We hope that our presentation was informative and insightful. Thank you.
Thank you.